Hey everybody, it's Squid. Welcome back to my channel. How is everybody doing on this Wednesday morning? I think it's Wednesday. Oh, I hit the live button and somebody wants to hang out. Girl, your hair. What'd you do? How is everybody doing today? Oh my goodness, it is a day. It is a day. It is a day. And I want to just get through these real quick. Thanks, Ung Hero, for the $2 super chat. Starting us off right. How are you? How is the better half? Everybody gives Ung Hero a congratulations because he put a ring on it. And Patrick W, thank you for the $10 super chat. So let's teach BBB math. If you have 118 docs and told only 3 more until April 3rd, how many docs should there be by April 3rd? Hint, the answer is not 122, 123, or 124. BBB can't do word problems. Touche. Y'all got me on that one. I hope everybody is doing great. And I'm sorry if I don't say hi to everybody this morning. We have a lot to get through. First things first, I want to get through the and Marcus, thank you for the $4.99 super chat. Good morning. Good morning to you as well. Oh my goodness. It's gonna be a day. It's gonna be a day. And of course this shit always hits the fan when I go to work. So I put it into, thank God for Speechify, because I had Snoop Dogg read me the filing last night. And I was like, oh God, this is cringe. This is cringe. Yes, Captain Kern, thank you for doing all your modly stuff. On your way in, smash that like button. Don't forget to share with your friends so they can enjoy my content too, or dislike it and leave me hater comments, which we'll get to. And make sure to subscribe for more awesome content. Oh, yes. Oh, my goodness. My goodness. Oh, no. Woke up to just sort of screaming whenever the weather changes, her back legs lock up. Oh, my goodness. Give that for baby a hug for me. Stop. Like, yeah, this should be a day, huh? And Jeff, I do have to thank you. And yes, I do have to thank you. Even though your note told me not to, I don't care. I am so blessed to have all of you here watching with me and hanging out and supporting my channel. Yes, we are on our way to 4K. We are on our way to 4K. We're at like 36:15 or something like that. I don't know. And Ung Hero, thanks for the $2 super chat. I have no idea why, but she said yes. Thanks, y'all. And Ung Hero picked out a gorgeous ring. I've seen a picture of it, and the man has good taste. Let's put it that way. All right. Hey, it's me. All right. Need to put on some lip balm because this is a little dry in here today. Oh, right. Which is funny because it's like 90% humidity outside. All right. Will BB be on a plane today? Probably not. But that's just that's just my personal opinion. I hope I'm wrong. Like I hope that he is, because like as much as I like to make fun of Bruce and I think Bruce is a horrible lawyer and an even worse person. I don't want to see anybody truly screw themselves. Like, I don't, like, I'm not, like, I don't, like, I'm not that big of a jerk most days, to where I don't want to watch somebody set themselves on fire, so to speak, and set their career on fire. I don't understand why certain things have happened or that people feel the need to do certain things. I just don't. Yeah, I can't. Like, my brain just doesn't compute the why you would want to kamikaze your career. Yeah. First thing I thought about was, oh my God, Squid's gonna go to town with this one. Yeah, I'm not going to. Okay, we'll see how this goes, because y'all will see how this goes. And Tammy, I'm still getting used to how these super chats show up on this on Streamlabs. It's kind of weird. Captain Kern and I still have to work together to figure out how to like make them pop up and come up and automatically be read. Whatever. Tammy RM, thanks for the $2 super chat. BBB never fails to annoy or not follow judge's directions. I mean, he seems to do the opposite. Oh, DUI guy just posted a nice synopsis if you didn't know. Okay. I mean, Jeff, chance of incarceration if he goes 10%, he gets nasty. If judge doesn't, he show 100%. Marshall will be coming from me. Yeah, that's the thing. You're scared of being okay. So we're just going to get into the hater of the day first. It went from hater of the week to hater of the day because, well, and I had these shared and they didn't want to finish working. I'm getting used to how to make this go quicker and how to like make this transition smoother on this platform. And I like it. It's still new, but I like it. So first things first, hater of the day. And I apologize to this person if this is not at all what you meant. I just can't sometimes. So this comment was left to me yesterday. You do like to me and ER all the time. I'm not sure what that was actually trying to say, but I interpreted it as you say like and me and too many times. And this is my response. And this is my response if you leave me a snarky comment. And I apologize to this person if this is not a snarky comment. But that does not make any sense. If you are trying to insult how I read or talk, please make your comment make sense. Thank you. I did not. I was trying to I was paying attention to the Wisconsin Supreme Court things yesterday. So if I now I'm just going to do it on purpose because it apparently annoys this person. And I know that sometimes I have a hard time coming up with what to say. Like, I know what my brain wants to say, but the brain fog is real. So sometimes I pause or I say because my brain wants to say what it wants to say, but my mouth can't come up with the words to say because, the brain surgery and the fact that I was like compressing my cerebellum and shit like that. Just just a minor inconvenience to people. I apologize. I not so think as you drunk I am. Hey, Yamaha, how are you this morning? Oh, and I can't imagine. Hey, Jim, how are you? I'm a 7, always like your videos, but I usually don't comment. Just wanted to say good morning. Good morning. Thanks for hanging out with us this morning. It is it's an interesting one, but we'll get into it. So I just want to, if you're, for all the haters that don't like my channel and feel the need to tell me that, like I'm supposed to care. And Unghung Hero, thank you for the $10 super chat. Imagine criticizing someone speaking with grammar like that. That was my point. If you were going to insult me or try to insult me, and like I said, this person, I don't know. So if I am wrong, I apologize. However, we can talk about that during another time, or you can email me. But you, for me, I was 33, I think, when I had surgery. 32. It was totally worth it because I can feel my legs. The problem is I can feel everything. Sometimes having no feeling in limbs is a lot better than feeling everything. But you know, just me. If you're going to insult me for future reference, make sure you have better grammar than me. I am not perfect with my grammar and how I speak and how I type, but this needs some work. I can teach you how to troll if you want to, because I happen to be very good at it. It's one of my favorite things to do. Ask my family. And thanks, Sharon. Never apologize for having health issues. You never ask for these health challenges. Yeah, it's just one of those things that it's people with neurological disorders or chronic pain. You can't, it sucks to be one of us because it's not pain that you can see. Like when someone has a sling and a cast, you know, they broke their arm, you know, you can see a bandage, you know, they had surgery. When you have a neurological condition, no one can see it. And on the outside, you look normal. And thank you, Tammy. How you read and comment is what makes you who you are. Seems like 3.61 plus like you as you are. I appreciate that. Yeah, it sucks so bad. Yeah, it's just yeah, and sometimes it's like I can't even think of the things that are like super, and maybe it's the camera too. I just like I'll be talking and mid-sentence I'll forget what I was trying to say. And that's part of the reason that all this, I'm just reading documents and commenting on the documents because the documents never change. And I can always refer back to a document. Trying to remember who's who and what's what and how many times they screwed over somebody else. I can't even figure that out. Like I just thank you to my Tammy. And hey Tomato 1016, how are you? There was a comment up here that from Yamaha that this is why it's very important to make sure Shizzy wears his helmet. We miss everybody else left. In fairness, Squid lived in the Cincinnati area for a while. Cincinnati is the graveyard of good grammar. Yes, I lived there when I was in like 2nd, 3rd, and 4th grade, though. I lived off of Fields Earl Road. I think that's off of either 71 or 75 or both. I just had the decompression surgery. How is your daughter doing? Was she doing better now? We're past the shaky part. Yeah, and people judge us. The pain can't be that bad. Yeah, like the people who, like, I feel the need to clarify some things because I've dealt with it all my life. Like when I say I'm in pain, but I went to the gym, It's not like I hurt my ankle or I hurt my wrist or I tore a muscle. There is nothing actually wrong musculoskeletally. So I can go to the gym, I can run, well, as much as my fat ass and poor lungs will carry me, but I can go to the gym because I'm going to be in pain whether I'm sitting here or I'm, yeah. Oh, yes. Hey, Mo, how are you? Yeah, that's how I feel sometimes too. Yeah, 71 and 75 are the same road for most of that area. I lived in what used to be Sycamore Terrace apartments. They're no longer that. And it was like next to Wellington Place or something like that. Like it was a nice area from what I remember. So life put me with some people who have nerve pain and like so many things. My grandma explained it to me in a way I could understand at 6 years old. I mean, that's unfortunate, but lucky for you. It's just one of those things you don't know until you know. And then when you know, it's like, holy crap. And Mo, you are loved. I'm so glad you were here. Thanks for popping on. All right, let's get to this fun shit show of a situation. And I have thoughts. And some of them I wrote down because I'm like, I won't remember. I won't remember the maybe that person took the same class as LP with comment makes no sense in a word in place of a period, bless their hearts. And I maybe they're wrong because I recognize that name and I don't remember that person being a hater, but I've had some people recently that went from saying like they loved me and they loved Baby Squid to thinking I'm the worst person on the planet for some reason, because someone told them so. Blah, blah, blah. So it's a crapshoot. My grandpa, my mom's dad used to have a hat that says I have or a bad case of CRS or something like that. It was on his hat. Can't remember shit. Ugh. All right. Here's this wonderful. We proved yesterday objectively when two different lawyers filed literally the exact same motion, they needed more time to respond to a complaint. You saw a good version and what a professional and competent lawyer would do. Well thought out, well written, communicated with the other lawyer. It was very like, I'm not a fan of MLS. Everybody knows that. But MLS hired what I believe is a competent lawyer just based on that. He very clearly, it was easy to read. There was more than one reason. There was no whining. It was objective, like family emergency, provable. Talked to lawyer, provable. Lawyer agreed to 7 days, provable. Like, yeah, it's crazy. And then we saw the paragraph from Bubbles where he not only didn't explain himself in a clear manner in the sense of bullet points, multiple things, spacing, single spaced paragraph, but he also went, but they didn't get served yet, so why do I have to respond? It's not the point. That's not the point. That's not the point. After hiking and looking at property in Tennessee and northern Georgia this past weekend, I just have fat guy pain. Oh, yes, it was squat day yesterday. Yes, he did get, well, no, wait. Patrick, I will look. I don't think he did. He might have, though. For some reason, it's not, my brain is not computing the case number. I'm getting the two mixed up. But yesterday on his motion in the new case for an extension of time, he did put the wrong address or the wrong case number. He did put the wrong case number. He put the case number for this case on a document for the new case. Thank you. I appreciate it. Welcome to the chat. How are you? He did put the wrong case number, so we are going to check. The new case is 0058RHZCB. I'm not sure what the old case is. I have to open up a different document. Federal documents. Let's see. I'll just open up anything. Yep, he did put the right case number. Yesterday's document that we read, he put the wrong case number, which is a rookie mistake. Maybe we should call the judge at home and set for time to discuss this. Yeah. Yeah, that would be icing on the cake. Yes, it's all because it's copy and paste with no proofreading. Like, dude, proofread. You know how many times before I write a comment to someone that I proofread it? Like, is this going to be taken the wrong way? Or when I say they, who am I referring to? Comments that are like, they said this. Who's they? There's so many players in this game that it's like when you say they said, it's can any of my mods drop my link or my email in the chat if y'all remember it? If not, I will. It's just I just I can't wait for all this to be over too. Like, I got other stuff to cover. I am so behind on some things, and I'm like, is it worth covering anymore because I'm so behind? Like, I did order a new planner that goes past June of this year so that I can write stuff down because we have trials going on in October. Christopher Schultz's trial is in October. We got stuff to catch up on. We got new things that I want to cover. But this is like the herpes of cases. It's a gift that keeps on giving and just won't go away. Like, anybody know if Megan put Bruce's picture on her wall of shame that she has? She has a bunch of pictures of people that needed to be mom shamed. And Bruce's should be one of them. I think Judge DeThomasis was the last person to go up there. Oh my God. After April 4th, I really hope she puts him up there. All right, let's get into this now that we've been here for 20 minutes. Motion to vacate consent to magistrate under 28 U.S. Code 636C4 and Federal Rules of Civil Procedure 73B3 based on extraordinary circumstances, including fear of arrest. And Patrick, thanks for the $2 super chat. I proofread everything. If Grammarly is looking for a spokeswoman, hit up. Yeah, when Facebook, when Facebook gets political and people decide to start, hating on people just because of who they voted for, which I hate. But when people do that and they insult somebody and they have very poor grammar and they can't spell, you can't really cuss people out on Facebook without being reported for violation of terms of service and blah, 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 and go in Facebook jail. So I comment on their grammar because it not only insults them, it offends them, and they get very butthurt. And then I hit them with a bless your heart, clutch my proverbial pearls, and say, I'm going to pray for your family because luckily I can shut off my phone or leave Facebook's app and not have to deal with you, but your family is stuck with you. Peppa background music. Oh, you can hear that. All right. If BBB proofread, it would cut into his time being praised by the JH haters on the flea bite site. Yeah, and the thing is love or hate Jeremy Hales, and whatever Jeremy Hales has done in his past has literally nothing to do with this particular case. Looking into Jeremy Hales' past, I haven't done it because I literally don't care, because none of that has anything to do with this. This is a completely separate issue than Jeremy Hales' ex-wife and kids. Don't care. They have no bearing on this case. So when people try to bring that up, it's like, that's not what I look for, because I really don't care about someone's past. I care about the current lawsuit and whether they have any bearing on this. Now that's going to be stuck in my head. Thank you. I personally think this is an attempt to set up another magistrate change, in my opinion. Yeah, it is one of those situations of I called this a while ago. So when I said that when people were mad at the judge for not getting mad at Bubbles or getting mad at Randy also, because Randy wasn't professional either. Yes, Bubbles was more unprofessional, but this is a black and white. Are you unprofessional or not? Not a who is worse. So I saw this coming, because with everything that he has filed in the past, this judge was being extra careful to give both attorneys very much, or a lot of leeway, a lot of rope to proverbially hang themselves with. We lost power a couple days ago for like 4 or 5 hours. Monday night we lost power, so I couldn't have streamed even if I wanted to because I didn't have power. I got a good video of my lights going zzz. So, all right. A lawsuit isn't to win a lawsuit. It's to make you spend all your money on a lawyer and bankrupt you. That's what a win is. I could care less if I win in court. If I win in court situation, my goal is to make sure you have no money. That is the goal of the lawsuit. Plaintiff Jeremy Hales. And we've established multiple times that this was taken out of context. And knowing what I know about Jeremy's personality in his videos, I don't talk to the man off of maybe a chat when I say hi to him. It was in jest and to prove a point. Like a lawsuit, a lot of the times when you have money, is not to win money. It's to stop the person from doing what they're doing and to prove your point. So it's, yeah. Well, sometimes Robert, sometimes when we have a battery backup that keeps our internet up for a few minutes, but not very long. So I can have no power and actually have internet. So it's a interesting conundrum I find myself in sometimes. All right. The complaint fails to plausibly allege a violation of Florida RICO statute in counts 3 and 4. Although plaintiff's complaint recites the language found in the extortion statute, a party does not allege a cause of action for extortion by alleging in conclusive form, which tracks the language of the statute, acts which lack factual allegations and merely state bare legal conclusions. The magistrate is granting a long pending 12B6 motion after been having misled into exercising federal jurisdiction by the complaint labeled as extortion, non-extortive statements influencing the amount in controversy calculation under 28 U.S. Code 1332. Well, problem number 1, counts 3 and 4 were thrown out. Second point, it's not about the final amount that enacts federal jurisdiction. It's about what the amount was brought in with. So counts 3 and 4, the RICO counts, were tossed. But just because they were tossed does not mean that it's still not federal. And the judge has made rulings on this more than one time. So to put this in there is stupid. And it's just going to piss the judge off, because the judge is going to say, I already said this. Also, this Bubbles fails to take into account that Jeremy is not a resident of Florida. He is an Ohio resident. Florida says you have to live there 6 months or more. It doesn't matter if you own property. I have friends that own a beach house in Florida. They live in Wisconsin. They're residents of Wisconsin who own property in Florida. Florida states, and I believe someone had talked about this in the chat a while ago, a couple months ago. In order to be a resident of Florida, you have to be residing in Florida for more than 6 months out of the year. I don't think Jeremy resides in Florida for more than 6 months out of the year. So therefore, he's not a Florida resident. Therefore, he is an Ohio resident. Ohio plaintiff, Florida defendants. Yeah, all this is copied and pasted together, with the exception of a few things that aren't in any other motions, but I believe they're inappropriate. The magistrate has ignored the plaintiff above quoted admission of abusing litigation to inflict financial burden, although it was read aloud in front of him. He has not addressed the issue of whether the extortion label was purposely misapplied to influence the exercise of jurisdiction, nor the plaintiff's apparent perjury and affidavit about online posts calling me a child predator that the magistrate also relied on. Problems with this paragraph. He is already litigating in a motion. He's trying to litigate the case, and this is where it starts. He didn't ignore your above quoted admission. The magistrate, most likely, because he's put it in every motion, and he put the link to the video. That's the one time that Bubbles, or the very few times, he's done it more than once. Give him credit. He's done it more than once where he's put evidence of links to videos. I'm sure the judge looked at that video, saw the context, and doesn't agree with Bubbles. Just because the judge doesn't agree with you does not mean he's ignoring you. It means he doesn't agree with your legal argument. He doesn't agree with it. You've said it multiple times. He has not addressed it, because he already addressed it when he said that the federal jurisdiction still stands in your multiple motions to dismiss based on subject matter jurisdiction. Oh, Daryl Brooks. Oh my God. Oh, Yeah, BBB is wasting the judge's time on already denied motions. The footnote says it all. Not only already denied motions, but already denied reconsideration motions. He's not ignoring you. He doesn't agree with you. It's a judge's job to not agree with you. You're not going to be happy with every judge's every decision. It's called life. If every defendant didn't agree or agreed with every decision a judge made, nothing would ever get done in this country. Like, Tug and Megan found out BBB clipped a bunch of JH's videos he put in this motion. Yeah, because he takes everything out of context. Remember, they cherry pick. So that doesn't shock me in the least bit. But listening to, I had to put this in Speechify last night. Listening to Snoop Dogg read this motion is even funnier than the motion itself. Footnote 1, the undersigned had originally intended to file a preliminary notice of intent to file under 28 U.S. Code 630-64, seeking a stay. But order number 118's footnote threatens sanctions should counsel file anything prior to April 3rd not deemed an emergency. This is not deemed an emergency either. The undersigned therefore expedited preparing this motion. So he told you not to file anything with the threat of sanctions because you've already filed multiple things that weren't appropriate to be filed. And yet you decide to file something anyway. You expedited this motion so that you could have it filed before April 3rd. What about that makes sense? Yes, I completely agree. BBB is trying to try this case via motions in the court of public opinion. I believe because he thinks he can persuade his honor by his immense law practice skill set before it all started. Yeah. Nobody likes me. Everybody hates me. I think I'll go eat worms. Even the clips have been edited. Yeah, that doesn't surprise me. That doesn't surprise me. I don't think I want to hope that he will, because if he doesn't, it's not going to be pretty. And filing this and then not showing up, I don't think the district judge, if they look at this, will if Bubbles doesn't show up, I almost said throw up. If Bubbles doesn't show up, this is going to be taken even worse than it will be if he shows up. If that makes any sense. It's did not play JH fully deleted clips out of the videos, took inserts of them. Yeah, they copied it, like they cut and paste, and after this motion, I think he plans on not going. Yeah, it's sorry, she's all right, but the immediate reason for this motion is the extraordinary circumstance that the undersigned validly fears being arrested by the magistrate during an ordered show cause hearing on April 3rd. This is coupled with the fear of threats from the plaintiff's followers to show up in Pensacola to see Deuce Foreskin, the anti-Semitic nickname ascribed to the undersigned by the plaintiff on YouTube, be arrested. I wouldn't want to go just to be arrested. I would want to go because it's not very often you get to see what happens in federal court. And I really want to see this judge. I really want to see the body language and the facial expressions and the presence that this judge has. That's why I want to go. Like it. Hey, baby. Angel, what are we? You want to FaceTime Daddy? No, you want to FaceTime Grandpa? Okay, well, I don't know what you want from me. Well, you just dropped it on your foot, so I don't know what you want from me, baby. Uh-oh. I gotta go. She spilled her water on herself, so I have to go do mama stuff for a minute. I don't have well, maybe I do have it. Yep. Oh, you want your yogurt too? Yep. We gotta go change your diaper first. No. Yeah. Okay, you can have this first, and then we will go change your diaper. But we have to go change your diaper like immediately. You go. I got one more paragraph in me. It's not her diaper; it's her water she spilled on herself and then sat in. Squats. I did squats yesterday. One set of 20. One set of 20. If you re-racked your weight before the 20 was over, you started over. Like. This is as the plaintiff has been promoting ever since the magistrate's order was issued. Is Jeremy doing some of it for clicks? Probably, but welcome to making your living on YouTube. But Jerry is probably already also laughing because Bubbles thinks he's never wrong, and now he has a show cause hearing. There is a hearing that Bubbles is literally the only reason for. You are the star. You want to be the center of attention, Bubbles. Well, here's your chance. The fear of arrest stems from the magistrate having threatened the undersigned with arrest prior to the plaintiff's live deposition on December 19th. Discussed further below, which the plaintiff has broadcast repeatedly for sensational content to stoke his followers. See video, that link. Events leading to this motion, documents 96 and 118. The April 3rd show cause hearing was ordered in response to a misleading and inflammatory motion for sanctions. surprise filled by the plaintiff's counsel and without a local rule 7.1c certification. See, he brings this up, but in the other lawsuit where he filed the motion for extension, he didn't file it either. So the magistrate immediately issued an order for an expedited response, document 97, and the next day, without any response addressing the merits of 96, ordered the undersigned to travel to Pensacola for an April 3rd hearing to show cause on why his pro hoc vice admission should not be revoked, document 98. There is no provision for a review of whether the motion for sanctions was contrived, baseless, or short of justifying such a response. Problem with Bubbles putting this in there is the judge has on multiple occasions told Randy and warned Randy and asked Randy to provide evidence to prove he's not. It was in yesterday's motion. Angel, we gotta go change your butt, okay? I will be back in a hot minute. I will see if I have the video of. Did I put it in there? Please say I did. I'm still not sure of whether I put certain videos in. If I put certain videos in I didn't. I thought I did. I swear I uploaded a video with my my hold music, and I can't find it. So I'm just going to stop the video, and I will see you guys in about 2 minutes. Thank you all for your patience, and I have no idea what happened to my the video I uploaded, my hold music. All right, back to this. He's already told Randy that he better not be doing this in bad faith. Multiple times. So I'm pretty sure if the judge had one inkling that Randy was doing this in bad faith, he would have called him out, because the judge has obviously shown that he is not afraid of calling out Randy too. Prior to ordering a live hearing that imposes unjustified major burden and expense on the undersigned. Quote, plaintiff has filed a motion for sanctions, document 96. The motion alleges defendant's counsel has engaged in unprofessional conduct. The court has ordered defendant's counsel to respond to the motion by March 20th, 2025, document 97. As a part of that response, defendant's counsel should show cause as to why the court should not revoke the privilege of pro hoc vice status that has been granted to him in this case. A hearing on this matter will be held April 3rd, 2025 at 1 p.m. And that is tomorrow. Order 98 explicitly preempted any request to make the hearing remote. Well, guess what? Sucks to be you. He wants to see you in person. Get over it. Having created the status quo, the magistrate thereafter, in response to a motion to strike 96 for lack of a Rule 7.1c certification, excused the lack of certification by ignoring his own cited precedent. See document 100, motion to strike 96 for number 7 or 7.1b conference or certification. Document 102, denying 100, ignoring his own decision in First Baptist Ferry v. World Inc. that was cited in 100. And we's going to get into that. But so we are going to explore for a second. We are going to get into document 100, which was, oh boy, all the way back, 104, 103, 98, 100. So we are going to mm, 316. All right. So this is 100. So this is Bubbles' response. Oh my God. So we're going to address what he says when he says it. Oh my goodness. Document 102, denying 100, ignoring his own first decision in First Baptist Ferry Passenger Inc. World Insurance Company that was cited in 100. The defendants filed the ordered expedited response, document 115, showing that the 5 emails on which the sanctions motion were based. Stop trying to litigate in a motion. One, containing an eggplant emoji, was not even the undersigned's email, but a journalist sent to both counsel, to which undersigned replied. You hit reply all, not reply. If you hit reply, Jeremy would, or Randy would not have gotten that email, and this would never be an issue. But you are a tech boomer. So you are a tech boomer, and that's your own damn fault. That is your own damn fault. Oh, thank you. I'm trying. Yeah, I wonder what is. No, never mind. The two merely use the acronym polyflop to respond to the plaintiff's counsel refusing to resolve any issues by stipulation, which is doubtful the magistrate understood. Him not understanding you means you need to be clearer. And also the fact that you wrote 50 motions, not sure if that's the exact number, but we did do the math on it, and Bubbles has filed more motions, and that's not responses, that's motions. Which means if the magistrate does not understand you, you need to fix you. That's not a him problem. That's a you problem. Breaking news, Bubbles can't attend to a sudden outbreak of polyflop. Don't give him any excuses. One was unrelated to this lawsuit altogether and was in response to the plaintiff's counsel doxing the undersigned and 9 other defendants' home addresses on the public docket of a second lawsuit initiated by the plaintiff for YouTube content. Bruce, the one who is making content is you, because all of my content is about you. Like, my content is not going into Lynette and John's past, Jeremy and George, don't care. Like, my content is all about Bubbles' crappy filings. So I don't, like, if Bubbles stops being stupid, I'll stop having content. Well, that content anyway. I've got other content. I had content before this case, and I'll have content after this case. only stating you're endlessly ridiculous. I put completely ridiculous in my description of this video. I'll have to change that to endlessly ridiculous. Was an email sent as counsel to the plaintiff's counsel in this case. Just why? Although document 115 itself shows cause why the court should not revoke pro hoc vice status by debunking that any of the emails in 96 remotely warrant court action, let alone the reaction it elicited. No, the reaction it elicited was like the judge's final straw. Like, the judge has been fed up and showed he's been fed up for many, many of his orders have shown that he's been fed up. But he has given everybody so much leeway. So much leeway. Like, hey, Flash fan, how are you feeling today? The magistrate did not respond to this filing, and it had no impact on the order for the April 3rd show cause hearing. He didn't respond to that filing because it was the same as 97, except for it added the judge was on the case of one of your case law that you cited. Having until then chosen not to multiply proceedings by filing, hold the phone, not to multiply proceedings. In this case, there are 123 documents. And this case is not even done with discovery. Discovery deadline is Monday. Yeah, April 7th, Monday. I just like, there's just certain things that you have no words for. Pot, meat, kettle. Hey, Melody. He forgot he sent out emails to a lot of YouTubers to talk about this case and his mac and cheese case. Now he's heard about it. Poor baby. Yeah. It's... Which part of no more filing motions did he not understand? I'm speechless. Yeah, and it's that and the fact that he expedited this motion, knowing that he could have brought this motion with him to the courthouse and filed it in person. Yesterday, Bubbles filed a motion to vacate the magistrate. Pot, meat, bucket. By filing defendants' motions for sanctions, although having a multitude of grounds for doing so, but with only the plaintiff's motion before the magistrate, and it having provoked orders threatening to revoke the undersigned's pro hoc vice admission, the undersigned felt it was imperative to alert the magistrate to at least some of the issues the plaintiff's counsel's conduct that, unlike the handful of private emails underlying 96, actually multiplied proceedings. Therefore, the undersigned prepared and filed as each was completed for 4 successive motions for attorney's fees. That could have been combined all in one. That could have been combined all into one motion with 4 separate causes of action. Probably the wrong terminology, but y'all get what I'm saying. I want attorney's fees for this. I want attorney's fees for this. I want attorney's fees for this, and I want attorney's fees for this. One motion, but no, he had to file it 4 separate times. That is what, if I'm understanding the judge correctly, that is the epitome of what he is talking about when he said there are 117 motions and this case is not even done with discovery. This is a one plaintiff, 2 defendant case with 117 docket filings, and we're not even done with discovery. This right here is the problem. Mind blown. Like, how does anybody not see that stuff like this is the problem? Not saying Randy is perfect, because everybody knows I have issues with some of the things that Randy does too, as a layperson, not a lawyer. But some things just look retaliatory and petty from Randy's side when he responds and how he responds to certain things. But this right here is the epitome of filing unnecessary documents. 104 and 105, especially because they were filed successively, could have been put into one motion. Yeah, I know, but I know, but technically, y'all, I understand that he did not follow what the judge wanted him to turn over back in the day, but technically, discovery deadline is not till Monday. So the judge will not do anything about it until Tuesday. Because technically he ordered him to turn it over, but technically the discovery deadline is not till April 7th. So April 8th is when all of that will blow up in his face, in my opinion. These elicited no immediate responses from the magistrate. Oh, there's footnote 2. I know of one YouTuber who sent the email to the court. I sent the email of when he tried to include people on the settlement offer. I got that email and I sent that one to the judge. I never heard a response, but I also don't expect a federal judge to respond to a YouTuber with 3,000 subscribers. However, I did send it to the judge like, hey, think you should be aware of this, and sent it off. So I did send that email, because for those of you who weren't here or weren't subscribed to me back then, I also did receive that email that Megan, Tug, and Shizzy all did. I received it too. However, the magistrate did respond when the undersigned filed a motion to dismiss under FRCP 41B and for sanctions, document 117, based on nearly 40 emails from the plaintiff's counsel over the course of this litigation, in which he threatened, insulted, or falsely accused the undersigned about everything and anything he could use to vex the undersigned, waste as much time as possible, and multiply proceedings. Emails don't multiply proceedings. Sorry, bro. Sorry, bro. Yeah. I had the minute that Shizzy said that in the state of Georgia that could make me a party to the case, knowing that Bubbles was trying to cause unnecessary drama, I immediately sent it to the court. So whether they got it or not, don't know, but I did send it, because I'm not getting myself into. There's a reason I only read legal documents, is because even though certain hater channels watchers said that I could be, or that I might be sued for defamation and RICO, reading legal documents and giving my opinion on public documents, not a suable offense in the in this country, because legal public document, personal opinion, public document, personal opinion, First Amendment. Have a nice day, people. Footnote 2, 104 was based on the plaintiff's counsel having forced the undersigned to seek leave and to file a reply to his 12B1 opposition to respond to his falsely accusing the undersigned of fabricating quotations from legal authority. Bruce, this right here could be written like 80 different ways, and every one of them easier than I could have written this like 10 different ways, 10, and every one of them would be easier to read and more than one sentence than this. So 104 was based on the plaintiff's counsel having forced the undersigned to seek leave, period. Also, to file a reply to his 12B1 opposition and respond to his falsely accusing the undersigned of fabricating quotations from legal authority, period. as well as several other misrepresentations. Document 105 was based on the plaintiff's counsel filing frivolous, timed for YouTube motions to dismiss counterclaims. This was based on the open and obvious false pretext that he had been named as a counterclaim defendant. I think that was a misunderstanding with the judge. I don't think that was Randy. I think that was the judge. Number 114 was based on the abusive deposition of a witness that had nothing to do with this case. I'm pretty sure. See, and this is my thing. Amanda Martin, if she was truly concerned about the conduct of Jeremy and or Randy in her deposition, why didn't she file anything? Why didn't she complain to the judge? Bubbles is speaking for her, but he's not her lawyer. Therefore, it doesn't matter what Bubbles says. It matters what Amanda Martin and her counsel say. That's another thing. Stop trying to bring things in that don't matter. Amanda Martin is not your witness. Amanda Martin is not your client. Let Amanda Martin speak for herself. Stop trying to speak for somebody. God, I hate people who are, but this is one of the reasons that I have problems with Bubbles. I have problems with people who get offended on behalf of somebody else. My father-in-law did this, was trying to talk to his so-called wife about being offended for something she said. Surprisingly enough, her actions in this case were not offensive to me, and I don't need anybody trying to tell me what I do and do not need to be offended by. That's one of my main problems with Bubbles, is he tries to act offended on behalf of other people instead of letting those people speak for themselves. And if they don't say anything, they obviously aren't offended enough to say anything, which means it doesn't matter. Stop trying to bring up stuff in your case that doesn't matter. That's a reason that the judge has a problem with you, is because you bring up shit in motions that does not matter. Sorry. Yeah, he's like, you're not mad, but I'm mad for you. And Bridget, you had a really good comment here. Can you imagine the conversations going on in the judge's office? I'm wondering what his staff thinks about all this. Oh, to be a fly on the wall. Oh my God. I just can't. Yeah, Amanda Martin was called to determine if she knew about the science. Other questions are also allowed. That is true. That is true. Yeah. It's a lot. It's a lot. Yeah, Bubbles was more offended by a hoodie Jeremy wore than the defamation that Element threw at Jeremy. Yeah, and there's like, therein lies the problem with a lot of this, is your priorities, people, and it's not just Bubbles, it's a lot of people in this country are focused on the wrong things. You are offended by the simplest things that don't matter how people live their daily lives, but especially when you're in a different state. But people get offended by those things, but don't get offended by things that actually impact their bottom line, how they earn money, how much money is taken from them by the government. They don't seem to give two shits about that, but they give a crap about the shit that doesn't matter, like a stupid hoodie with a Cleveland Indians. And sorry, it will never be Guardians. It will always be Cleveland Indians, because that's just the way it is. Like, it's just one of those, like, your people's priorities are in the wrong thing, and it's frustrating as hell. And this right here is a prime example. 116 was based on the plaintiff's counsel failing to pay half of the December 19th court reporter cost as ordered in document 43, then attempting to extort the undersigned, then sue on a threat of sanctions to pay him for half the cost of a copy of the transcript he'd separately ordered. Hoi, oi, 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 oi. Hey, Missy. Yeah. Like, hey, Taz. It's, yeah. It's a throat tattoo. Oh boy. Email me. I wonder if any of the staff for the judges watch any of the YouTube channels out of curiosity. I don't know. I am not scary. I'm just. Oh, shit. All right. 116 was based on the plaintiff's sentence, then attempting to extort him, pay half the cost copy of the transcript he'd separately ordered. I do want to see Randy's receipts on that because I have a feeling that is not what happened. Dude doesn't even believe Steno that they billed in full separately each attorney. Yeah, I can be scary. I'm trying to be scary. Lisa. His Bach ticking trick. Someone somewhere will be offended. He is the creator of chaos as he is a letdown to mankind. Won't crap. Someone will. He'll insert himself and be a social parasite. Hey, Batman. Email me, and if I can help, I will. And if I can't, I'll let you know. Because sometimes I can, and sometimes I'm like, I can possibly tell you who to talk to, but I can't help you. Almost immediately after this motion was filed, the magistrate issued a rage-filled order, document 118, creating an alternative impetus to proceed April 3rd, regardless of the baselessness of order number 98. The judge disagreed with you that 98 was baseless. The judge disagreed with you. And tell your wife to give you your balls back and realize that you are a grown-ass man and you don't always get your way. Yeah. That right there. Donald Roberts, you said it perfectly. Striking all four motions under 28 U.S. Code 1927, stating the motions all seek the same relief and should have been filed as one motion. But yet you chose to file four different motions, adding four different motions for the same thing on the docket. Any idiot should have known. I know, and I'm not a lawyer, that you could file all four of those documents into one document and state, I want attorney's fees for this reason. Then I would also like attorney's fees for this reason. And I would also like... Jeez. Flash fan. Starting drama. Footnote 3. B, falsely equating both counsel for abusing this litigation and multiplying proceedings with frivolous filings. Just because you believe, and I don't even think Bubbles believes his own bullshit, just because Bubbles thinks his motions aren't abusing litigation does not mean the judge agrees with you. The judge is pissed at both of you guys for filing frivolous motions. Guess what? Suck it up. Suck it up. Preordaining the imposition of Rule 11 sanctions on both counsel based on past filings the magistrate selected and now deemed frivolous post hoc with no analysis and no prohibition on any responsive filings, and warning he would impose sanctions for any filings prior to April 3rd that he deems non-emergency. That is within his... Bubbles is getting dumber. Is anybody else losing brain cells? Is anyone else losing brain cells? Yeah, he took this case for free. Now he wants money. Oh. Yeah, I'm sure he does. Deborah, I'm sure he does. It's footnote 4. There was no explanation for why motion 117, based on the plaintiff's counsel emails, incited the magistrate, as the additional orders in 118 were not even directed at 117, but at the 4 previously filed motions under 28 U.S. Code 1927. Because he never responded to those motions, because you filed those, and 116 and 117 were filed before... or 115 and 117 were filed before he had the chance to respond. So he was ordering, the judge wrote 118 for all of those things. He didn't need, and this is where it's like, this right here is where Bubbles does not understand, in my opinion, the flying bullcrap that he's throwing and the multiplying proceedings, because the judge wrote one order to encompass everything that he hadn't addressed yet. Instead of writing, in Bubbles' mind, I believe in Bubbles' mind, he wanted the judge to write separate orders for each motion. That is what you call multiplying proceedings. The judge wrote one order to encompass all things, because he only wants to write one order. He only wants his clerk to have to file one order, because he does not waste judicial resources. He does not use and abuse his staff by making them file multiple things when he could address it in one order. Hey, Juliet. Oh, I don't think the best teacher in the world could help him. Oh. My great grandmother had a saying, the more I talk to you, the dumber I get. That rings true for Bubbles. Yeah. Bruce wants Randy to have to pay multiple sanctions, which is why he wants filing separate. Yeah, and also he wants to waste judicial resources, because the more that's on the docket, the more that they have to read. And when he does ask for attorney's fees, he can ask for more because there's more on the docket. Yeah. That I'm pretty sure. This is how you waste judicial resources. And at past filings, suddenly declared frivolous by the magistrate in support of preordained Rule 11 sanctions and the omen that counsel must bring their checkbooks. Should the judge probably have said that? No. But was it funny? Hell yeah. I know, Clark. Oh my God, I know. Oh, don't remind me. Ugh. You know. Footnote 3, no rule or authority was cited in striking the motions. Each involved a separate and distinct issue and sought separate relief from the form of attorney's fees and related to this distinct issue in each separate motion. If the titles had added re-frivolous motions to dismiss counterclaims and re-abuse of deposition to harass non-witnesses and re-false, you're telling the judge how to write his orders. False accusations of fabricating quotations, attempted. I'm not even going to read those. It would have been more clear that the motion sought relief for different matters, but under the same statute. The orders are a triple whammy on the undersigned, who represents the indigent defendants pro bono, regardless of the outcome of 96, due to A, cost of the trip, B, 3 days lost from his law practice, like the last time. See, Bruce, this right here was not necessary. This right here was not necessary. This right here was not necessary. And see now. You want that unlocked? Okay, bring it here. Bring it here. Bring it here. Can I have it, please? No. I will unlock it, but you have to bring it here. She's back in the room and wants her iPad unlocked, but she won't bring it here. She just keeps saying, "Pad, bring it here." Yeah. And what law practice? Yeah. Well, here's my thing. This is one of the other issues that I have with Bubbles, is he took a case in Florida, knowing he wasn't in Florida, and took it anyway. Took it anyway. Knowing, and okay, and this is a cultural thing, and I'm sorry to anybody who lives in the Northeast, but the Northeast and Florida took the whole face-to-face court proceedings and 2020 issues, handled them way differently. One was locked down for a lot longer than the other one. One got back to face-to-face and doing things in person and realized that COVID, like other chronic viruses, is not going away. So we have to deal with it and figure out how to live our lives with it. Whereas certain areas of the country, most likely the area that Bruce is from, took things way too far for way too long. And they got used to doing everything by computer. So Bruce assumes that the rest of the country will do everything by Zoom as well, where Florida is like, nah, bitch, we do shit face to face. We do shit face to face. So that's for those of you not in the US, that is the cultural difference between some people up north in certain areas and Florida. Florida said, we're going to have to deal with it. We might as well learn how to deal with it, protect the people who need protecting, and everybody else just go do your things. Well, Bubbles is very caring, benevolent. Okay, I can't, making myself laugh and sick at the same time. Yeah, I couldn't either. Sorry, Yamaha. I did too. I lived in Wisconsin and Georgia during 2020. I moved to Georgia in 2020, and Georgia had signs on the doors of every businesses that said, it's not masks not required, but you are responsible for yourself, and that if you get sick by being here, it's not our fault. I did not get COVID until 2023. I worked with COVID patients in the ICU, in regular COVID units. I worked with people in 2020 when I got down here, very few times wearing a mask. I did not get COVID until 2023 when Mr. Squid was sitting next to somebody who got diagnosed with COVID and brought it home. So it's not a matter of when you're going or if you're going to get it, it's a matter of when. And just being as healthy as you can be, taking care of yourself will help you get through it. Did it suck? Yeah, but so does the flu. And the only times I've gotten the flu is on years that I've gotten the flu shot. Is that a coincidence? I'm not really sure. So, ew. I still see tons of people wearing masks. And they are appropriate for some people. They are appropriate for some people. Like if you are actively coughing, it is polite to, when you go out in public, just don't share your germs. That's an appropriate thing. But it's the people who are riding motorcycles, not wearing a helmet, but wearing a mask, that make me kind of laugh. But that's it. Yeah, people wore masks before COVID. Yeah. That right there. Wearing masks, driving alone in your car on a freeway. Like if you're in a vehicle with someone who's, say, a cancer patient who's immunocompromised, of course, totally appropriate. But walking down the street by yourself on the sidewalk wearing a mask is just it's just, it is what it is, and they're like, it's appropriate for some people. It's at certain times it's appropriate, but to wear it all the time thinking it's going to save you from COVID, there's a reason COVID particles are smaller than like paint particles, and there's a reason when you paint a car you have to wear a respirator. So think about that paper or that t-shirt material that you have over your face is not going to stop anything. Just saying. Yeah, or driving for Uber and Lyft with no rider. Yeah. So like, yeah, it is. And that it's their front desk staff. If they're not actively like in a patient's face, like I don't know, a dentist, but they wear masks anyway because they don't want to get any of their germs on you when they're like this. But the front desk staff, I don't have an issue with the front desk staff. I have an issue with the dentist, but they wear them anyway because it's appropriate. I know. Yeah, pretty much. Especially when you're reusing the same mask over and over. All right. The orders are a triple whammy on the undersigned, who represents the indigent defendants pro bono, regardless of the outcome of 96 due to the cost of a trip, 3 days lost, and now Rule 11 sanctions imposed without an opportunity to object. Duh. See, Debbie, that's appropriate. Or Deborah, that's appropriate. That's appropriate if you're sick, because those masks also keep things from getting out. They don't stop things from getting in. That's the other caveat with those just paper hospital masks. But that's a whole nother story, and I could show you the research on it, but we don't have time. It's even better when the CDC put out the warning against wearing the masks in fire situations because the ash can get through, but you can't exhale. Viruses are much smaller. Fair. The magistrate's prior threats to arrest counsel on December 19th. The undersigned's fear of being arrested on April 3rd stems from the magistrate having previously threatened to arrest him on December 19th prior to a 2-hour redeposition of the plaintiff ordered by the magistrate. And didn't he threaten to arrest everybody, not just Bubbles? Correct me if I'm wrong. But that was like... I'm just saying, that wasn't just Bubbles. So once again, he's internalizing things that were made as a blanket statement. Sounds like a Bubbles thing to do. To occur in Pensacola after a remote deposition was terminated due to plaintiff's and his counsel's conduct. Your conduct too. I read the deposition transcript. I read it on stream. Yes. You toe? Would you like to come up here? Okay. Come on up, boo-boo. Come on up, baby. Yeah. Okay, we got to turn the volume down, though. Ready? Push this button right there. There we go. Yes. The judge said he had the power to have martial arrest for misbehavior. Yeah, it wasn't... It's one of those things, if you think someone's talking about you, it's just crazy. On December 19th, the magistrate said to the undersigned, the plaintiff's counsel, and the plaintiff, dude, doesn't he always contradict himself? And Stats, thank you for the 149 super sticker. How are you? Oh, yeah, and that is, but that's an appropriate time to wear a mask. That is an appropriate, that's no need to apologize. That's appropriate. There are appropriate times to do things and inappropriate. Like, I don't know, saying that you're scared that the telling people that you've never done anything wrong in this case, but being scared of arrest and then internalizing something that the judge made as a blanket statement to all parties involved. I'm warning you, I have the power of contempt and will not hesitate to use it by calling in the marshal and having you arrested, placed in handcuffs, and brought to jail if you do not behave. He repeated the threat casually several times before the deposition commenced. Hi. Hi. You're silly. The threat was outrageous and unwarranted, not based on what the judge saw and how he felt about that first deposition, and based purportedly on the magistrate's unjustified belief that the undersigned's conduct in his own remote deposition of the plaintiff on December 2nd equated to that of the plaintiff and his counsel. The judge made a blanket statement. Yes. The judge. Yes. Yes, the judge set ground rules. Squid, Duncan Idaho, thanks for the $5 super chat. Squid, hold up a minute, please. I'm trying to hear what baby Squid is saying. Hey, what you doing there? Oh, okay. You want to get down? Bye. Bye. Okay. Oh, you want to get back up? Okay. love your new co-host. Thank you, guys. Yeah, that's true right there. All right. In his own remote deposition of the plaintiff on December 2nd, equated to that of the plaintiff and his counsel that led to the undersigned's termination of that deposition. He drew this false equivalency, even though the plaintiff's counsel had sought an order or even asserted in any filing that the undersigned had acted inappropriately. Actually, there you go. Actually, Randy did say multiple times that in the deposition that Bubbles was being inappropriate, and the judge said that everybody was being inappropriate. So the whole Angel, you want to get down? No. Okay. He drew this false equivalency, even though plaintiff's counsel hadn't sought an order, even asserted in any filings that the undersigned had acted inappropriately. The magistrate's false equivalency of the undersigned with the plaintiff and his counsel was employed sua sponte, evidently to justify ordering a live deposition in his courtroom. The judge had to babysit y'all because none of y'all could, and this is not just Bubbles, this was Randy and Jeremy too. Only Randy and Jeremy admitted it. And Jeremy took responsibility and acted like a freaking adult. Like, I'm not saying that Jeremy is perfect by any means, but when someone tells you that, yeah, especially in a YouTube video, that, yeah, I screwed up, I'll do better next time, that is called being an adult. That is called being an adult. Like, it's... Do you want to FaceTime Grandpa? Yeah. Yeah? Okay. Here, go FaceTime Grandpa. Grandpa asked if he can FaceTime you. There we go. There you go, boo. Sorry, my dad sent a text message that I didn't see that said, can she FaceTime? Yeah, the first deposition, the ecosystem was bragging about Randy and Jeremy falling for their trap. Footnote 5. The undersigned in 27 years as a litigation lawyer in a state and federal courts was never before accused in writing by a judge of acting inappropriately, but false, fake news, or unprofessionally in a deposition or proceeding. Yeah, that's not entirely accurate because there was a lawsuit that he was involved with that was kind of all about his conduct. But we're not getting into that because we're only covering this. And to be fair, can you go get mommy's phone? No? We gotta turn the volume down a little bit. Okay. It's Grandpa to the rescue. Yep. Yeah. Everybody say hi to Grandpa. Yeah, hi, Grandpa. Not all of them. Not all of them justify a response. And technically, he has to respond to some, but there are some that, especially when the judge responds first, that he doesn't have to respond to. So it's not entirely, Baby Squid says she doesn't like this case. I want my grandpa. Yeah. The undersigned did not do so in this deposition, notwithstanding the magistrate's false equivalency. Indeed, expecting in advance the plaintiff's aim would be to provoke him, the undersigned prepared to and did remain patient for the entire 5 hours of abuse. Nope. You antagonized. The undersigned requested the magistrate to order production of audio backup of the deposition to demonstrate the plaintiff's unhinged demeanor, which would be relevant to the motion for a discovery of sanctions, including sanctions against counsel for allowing it to go on unabated and refusing multiple requests to control his client. Although the magistrate ordered the transcript filed, he denied the request for audio. Well, yeah, because he got all he needed. And in his opinion, he got all he needed from the transcript, and the audio and the money that it cost to get the audio was not required. It's yeah. Where's Grandpa? You want your head? Does your head hurt? Or what happened, baby? What happened? She's pointing at her head, but she's fine? Okay. You got to go over there and talk to Grandpa, okay? No. You want your pad unlocked? No. Show me where your bike is. Go show your bike. No. Grandpa, we got to go. Because she's not wanting to, yeah. Okay. All right. Say bye. No. Well, you got to get down then. We got to choose. Oh, no. Oh, no. Grandpa? Yeah. He only knows what's presented to him in filings. So when one side is immature and the other side drops down to somewhat of that level, it's yeah. And this is true too. You want to talk? You want to call Daddy? Yeah. Okay. You want to call your daddy? Yeah. Okay, baby. Okay. Okay. Hold on. I'm gonna call Daddy. Gotta get down though. No. Well, then you can't call Daddy. It's like you either can stay up here and hang out with me, or we can't call Daddy when Mommy's streaming. No. It's okay. You gotta get down then. So although the undersigned terminated the December 2 remote deposition, to seek an order based on the plaintiff's and his counsel's conduct, the magistrate's solution was to make him travel from Boston to Pensacola for a 2-hour deposition at a disproportionate personal burden and expense, despite that it was the plaintiff's and his counsel that precipitated. No, everybody did. Only 2 parties took responsibility. The third party did not. And you took a case in Florida knowing that you did not live in Florida. Stephen, oh my goodness. The magistrate's arrest threat was broadcast by the plaintiff for sensational profit-generating YouTube content. Okay, I have a problem with here. There's a reason YouTube monetizes people, and I'm sorry when you are making YouTube content about your life, and this is your life, and YouTube is how you pay your bills. You got to do what you got to do. So I don't fault anybody for making money on YouTube because I make money on YouTube. This is how I pay my bills. So content beginning immediately after he exited the courthouse. And also this, just as much as Jeremy is making YouTube videos about this, there are some other people on the other side of things, on Bruce's side of things, who are making money off of this too. So I like how he puts it on just one group of people when he's making money off of it too. Or his associates are making money off of it too. Beginning immediately after he exited the courthouse on December 19th and repeatedly thereafter. Yes, because people wanted to know. So when he was free and able to make a short video on it, he did, as most people do. Order 118 has led to a storyline on the plaintiff's YouTube channel and others profiting from the content generated by this litigation. you profit, or some people on your side of the case profit from that litigation too, douchebag. That Deuce Foreskin is likely to be arrested and jailed, with some vowing to travel and attend the proceedings in Pensacola April 3rd. Yes, because they want to see the shit show in person. The undersigned legitimately fears for his safety from that, in addition to being arrested by the magistrate. Equally unsettling at the time, following the December 19th live deposition, the magistrate, still on the bench, threatened to order you two to go out to lunch together in an attempt to insult the lawyers of plaintiff's counsel on the underside. No, it's to force you to get along like fucking adults should. Sorry, do not say that. Okay? Okay. Oh, it's to force people to act like adults should. Poof. 4Note 6, please scroll through document 17-1, a color-coded transcript of the plaintiff's December 2nd remote deposition, green, tirades and insults, yellow, really, really, really bad to put yellow in a document on a white piece of paper. The contrast sucks. Non-responsive, and you're just going to make people mad. Red, direct threats by the plaintiff to counsel. Blue, improper conduct by the plaintiff's counsel, including refusing 4 explicit requests to control the plaintiff. Footnote 7, in other videos, the plaintiff suggests that having ex parte communications with the magistrate leading to the present situation. The magistrate has told us to file a motion against him for sanctions. From the magistrate's own mouth, file a motion for sanctions, and he would bring him to Pensacola and rule on it. He also made fun of the defendants being forced to come to Pensacola with Preston's child. Wait, isn't Lynette and Crook who said nobody can be around this child because of a life-threatening disease? Disease is not life-threatening. It's very manageable. I've did a whole video on it. That people on both sides got mad at me for, because I was being biased towards both sides apparently in that video. I guess that when you're trying to be impartial, both sides get pissed at you. It's quite funny. Nobody can be around this child because of a life-threatening disease. Who's going to be with that child? The child can't come into federal court. When the undersigned explained he had a return flight to make, the magistrate suggested having it rescheduled, but after a short period of visible dismay on the undersigned's part, stated he would allow you to make it. The undersigned felt intimidated. No, you just feel intimidated because you can't push around this judge. Well, like that's the only thing. He can't push around this judge, and this judge gets mad because he can't persuade this judge to do what he wants just by complaining. No F words, baby squid, unless properly done and context appropriate. That link is active. Oh my goodness. Like Harley was with. Nope, that link is active. Ooh, let's see. Should we watch it? Oh, now you know this is gonna mess things up, right? Oh my God, Jeremy's thumbnails, man. Should we watch it? Yeah, I don't know. Okay, I gotta go back. Maybe it did open it up. Okay, but I lost my page. That's why I didn't want to do that, and I shouldn't have. But you know. Oh. Considering the magistrate's prior threat of arrest and arbitrary orders, disproportionately burdensome because you don't live in Florida, but yet you took a case in the Northern District of Florida like a freaking idiot. You thought that you were never going to have to go to Florida. Are you insane? Are you insane? Please tell me that he seriously didn't think he was going to have to go to Florida when he was taking a case in the Northern District of Florida. It was unduly burdensome to you because Jeremy and Randy live in Florida. Yeah, I'm positive that doesn't surprise me at all. That doesn't surprise me. Considering the magistrate's prior threat of arrest and arbitrary orders disproportionately burdensome, costly, and prejudicial to the defendants, no. Footnote 8, together with the tone and the content of orders 97, 98, and 118, the undersigned legitimately fears being arrested if he attempts to zealously defend him against the plaintiff's motions. Rule 11 sanctions, or I couldn't say that as whiny as I wanted to, or the revocation of his pro hoc vice status. The undersigned's advocacy in this case has been completely chilled. All right. Footnote 8, such arbitrary prejudicial orders have been made on several other issues that are not directly involved in this motion and have themselves resulted in multiplying proceedings that could have easily been avoided. Document 61 and called a request for extension of time to disclose a rebuttal expert, which needed to be ruled on prior to the deadline for counterclaims, or else the filing a counterclaim would become necessary to enable an expert in chief that would also serve to rebut theirs. The magistrate initially ordered an expedited response, apparently to enable a timely ruling, but after the plaintiff filed a 14-page opposition, not arguing prejudice, the strict application of the rule, a pure gotcha, the magistrate failed to rule so that the undersigned had no choice but to add the counterclaim. Oh my God. The magistrate then denied the extension as moot. Like, mwah. Those orders are based on BM's own instigations. He should have asked professional questions, like, were you present when the signs were found? So you can't testify directly how many people saw them. I'm sure he has a checkbook, Deborah. I'm just sure there's nothing, any check he writes might bounce. But I heard there's multiple, like, GoFundMes, so where's that money going? Yeah. That's sad. But I'm glad he got to be in a Top Gun 2. Document 66, overruled discovery objections with no hearing necessary. Because your objections were blanket objections. Well, I can't remember what the judge stated them as. I'm sure one of y'all know, but my God, I hope not. He ruled that the objections were blanket statements. Basically, you can't make, and I can't remember the term he used, so I apologize. It's she's watching shorts. Hey, Elu, how are you? He's so broke. PayPal unfriended it. Yeah. Well, obviously, the judge is not going to recuse himself because he's done nothing wrong. But if he doesn't remove Bubbles now from this case, something's wrong. Yeah, part of me is like, let Bubbles stay because Bubbles is making every boilerplate. Yes, boilerplate. Thank you, Kat and Aussie. I could not remember the term for some ungodly reason. I don't know. Maybe because somebody between mom brain and Kiari brain, can't remember. Oh my God. I will look it up in a few seconds. We only made it to page 8 in almost 2 hours. No hearing necessary, despite the counsel had been ordered to hold a telephonic discovery conference following the filing of the plaintiff's motion to compel, due to plaintiff's counsel having refused to do so prior to filing the motion. Document 53, the magistrate had stated if the parties are unable to resolve the issues raised in the motion, counsel should expect a hearing will be scheduled shortly after defendant's response is filed. The discovery in question involved the plaintiff's demand for 5 years of the defendant's phone records, when the undersigned sought reconsideration in light of having relied on should expected a hearing in maintaining objections. The magistrate denied it with no response necessary, ignored the substantive objections and legal authority briefed in expectations of a hearing. He didn't ignore it. He didn't agree with it. There's a difference. He didn't ignore it. The judge does not ignore anything. He just doesn't agree and doesn't feel the need to tell you he doesn't agree. He just denies your motion. Him denying your motion is not saying I ignored it. It's saying did Bruce show any real medical proof of needing any medical yet to claim she can't be around people? We have yet to see it, and why no required. I don't know. I have no idea. But her condition does not have anything to do with her immune system as far as being around other people. It is her body cannot break down certain, and it does not have certain enzymes and cannot break down certain things. It can cause cognitive issues, but it is generally, with proper medical care, managed. But it can cause neurological deficits and strokes if not managed. So I saw it, or I know now. It's we're gonna get through one before we start with the new one, because this one's gotten some summary of the claims. We know all this, like, so I'm skipping what we already know and what we've been told multiple times in multiple filings. Extortion claims and allegations, online posts calling me a child rapist, leading to exercise of federal jurisdiction. So we've read this. He's just quoting other things. Reasonable, the act that a successful plaintiff may receive reasonable attorney's fees, Florida Statute 772-104, and the 11th Circuit has stated when a statute authorizes the recovery of attorney's fees, a reasonable amount fees is included in the amount in controversy. So the fact that this case has cost thousands and thousands of dollars in attorney's fees means that that's included, therefore it stays in federal jurisdiction. The magistrate concluded when the possible actual damages are combined with the possible treble damages, the possible reasonable attorney's fees, the court easily finds it's more than likely, or more than not, that the amount, more likely than not, English, that the amount in controversy exceeds $75,000. Plaintiff's admissions during his December 19th live depo. He repeats this. In addition to the December 19th deposition in front of the magistrate, Hales was unable to identify an online post calling me a child rapist. He admittedly he could not identify anybody who saw the road signs except 3 friends of his. It's a public highway. He's not going to know every... Oh, your water? Watcher? He's not going to know everybody that saw them. And he's not going to be able to identify, because if I'm remembering correctly by the people who live in Florida, they have told me on multiple occasions that that is a tourist area. They're going from one place to a tourist area in a highly traveled road, not stopping in Otter Creek, but like people to get from point A to point B. And Otter Creek is just like a stop sign in the middle. So it's... Yeah, did he just fill his pages with other motions like the judge did? Yeah, like the judge didn't write them. Yes. It's... Oh my God. He admitted using defamatory statements to persuade customers is nothing more than contrived phrase to devoid any substantive meaning beyond allegedly making his statements. He admitted having no contracts at the time of filing the complaint, and that he was claiming interference, but was now claiming interference with whatnot, a contract he procured months later. Okay, correct me if I'm wrong, but even though you don't technically sign a contract, YouTube terms of service are a contract. Facebook terms of service are a contract. When you hit that agree, you are signing a makeshift contract that you will do what is in this terms of service. Otherwise, you will be booted from the platform. I'm just saying. Oh, and thank you, Duncan, Idaho, for the gifted memberships. And thank you, Duncan, Idaho, for the... And I'm sorry, it doesn't allow me to show these things on screen when I miss them. That's one thing I haven't figured out about Streamlabs yet, is trying to I'm just trying to find it going back. But can I trouble you for a brief bird's eye view of what's going on here? It's it's a shit show. And then Duncan Idaho, thank you for the 5 Squid Proco memberships. Awesome. I having to go in studio to find them, but I can't bring them up. That's the weird part. It's Flash fans, StreamYards or Streamlabs so far. Some things are better. It's cheaper. Some things are better, but other things are I'm not particularly a fan of. Like StreamYard lets me or stars all the super chats so I can find them quickly. I go to a little tab that says starred and it shows me all the super chats and I can bring them up on stream. Here, I can't, that I'm aware of. Yeah, that's not quite allowing me to do that. And I don't know how. I'm sure there might be a way. I'm just not smart enough to figure it out. Judge needs to see the email BBB sent to whatnot. Yeah. And yes, and thank you, Gabby. I do have a Venmo and a Cash App and a PayPal. So if people want to support the show but do not want to give their money to YouTube, which I can understand because some people are not fans of YouTube taking 30% of, somebody's earnings. But it is what it is. A contract procured months later. However, he admitted to making no contact with anyone at Whatnot to determine if the defendants had been in contact with Whatnot. Hi. The plaintiff with the magistrate on the bench testified that he plans to prove his claims with a handwriting expert, a traffic study expert. Here you go. A traffic study expert to establish how many motorists pass by the location, and an economic expert to establish that the universe of possible causes the plaintiff's income from YouTube allegedly decreasing is caused by isolated social media comments and posts by Preston and Cook among thousands of individuals commenting about the plaintiff online every day. That's 3 experts the plaintiff needs to put on his case in what the magistrate called in document 118 the simple 1 plaintiff and 2 defendant defamation case. Dismissal of extortion. Yes, everybody knows the extortion claims were dismissed. And he says, thus, treble damages and attorney's fees for extortion should have never been calculated for purposes of 28 U.S. Code 1332. And that's where Bruce is misinterpreting the law, because it's not about what cases go or counts go to trial. It's what were brought originally. 12B1 motion and terse denial 6 weeks later after show cause order. He's angry at the judge. 3 experts is not a lot. Yeah. Oh no. Has Whatnot to set up and sell. No contract is needed. I have to add more to it, Tammy. I'm kind of like, not that I don't want to show it, but you guys have been so sweet and so supportive of this list that I'm kind of like, I kind of don't want to I don't want to take advantage of my blessings and add more stuff to it. So it's just one of those, like, I'm thinking this is going to be like the last day that I add anything to it, unless specifically asked, because I'm not that, I feel like I'm taking advantage of my, overstaying my welcome with that Amazon list. The now established falsity of the plaintiff's statement alleging online posts by the defendant accusing plaintiff of being a child rapist, which was interposed to overcome the defendant's first 12B1 motion and specific reliance on which court denied that motion. In the plaintiff's admission that the allegations the defendant to use their defamatory statements to persuade plaintiff's customers to stop supporting his businesses does not refer to any additional actions or conduct apart from simply making the alleged statements. Okay, Terms of conduct on social media is the contract. They offer tech use of their system, click agree. And that's what I thought. Like, I don't know how well that would like hold up in court, but like, it's one of those, like, technically speaking, that's a contract. When you hit agree to terms of service on anything and you break those terms of service, you breaking your contract, they can remove you. His footnote 9, the magistrate denied dismissing tortious interference counts. He's basically telling the judge everything that the judge already knows. It's, yeah, I don't see the district judge giving this much. Yeah. This decision completely ignored a reply that the magistrate specifically granted the undersigned leave to file, which detailed several misrepresentations contained in the opposition to 12B1, including the outrageous false accusation that the undersigned fabricated a quotation from the case law to mislead the magistrate about the law. I do not think that you're going to win this one, Bruce, because it's not that he always said the judge ignored. The judge isn't ignoring shit. The judge just doesn't believe you, the judge is just not on your side, but instead of explicitly writing out everything that he doesn't agree with, he just denies your motion. He doesn't have to tell you why he denied your motion or the implications of every little thing. He denies it, gives a reason, but he doesn't have to tell you, I looked up this case law and this case law you miscited. No, he just doesn't agree with your reasoning for not wanting it dismissed, so he's not going to. And it's something I want to do. I enjoy your show. Baby Squid needs her own super Amazon gift chat. I appreciate that so much. It's just me not. Yeah, Randy didn't misrepresent that case text quote. BM did. Yeah, but Bruce is not understanding that everybody just, he's not going to win everything, and the judge is not ignoring you when he doesn't put something in a motion. He just doesn't agree with you. It's like, it's not. Oh yeah. Yeah. The way Bruce wrote his argument made it seem like he was making a quote. Yeah. It did. It did. There's nothing more to. Order 103 denying 12B dismissal came 3 days after the magistrate had issued order number 98 in response to the surprise uncertified motion for sanctions number 96. 103 did not meaningfully address the factual issues, going directly to the plaintiff's improper invocation and undue influence on the exercise of federal jurisdiction. Stop trying to make fetch happen. It did not discuss the complainant's misuse of the label extortion. Magistrate's inconsistent and arbitrary orders on Local Rule 7.1c. There's a big problem I have with this. Magistrate has enforced or disregarded Local Rule 7.1c certification requirements arbitrarily at his own whim. Local Rule 7.1 is a gateway to literally every other motion than dispositive to open or slam shut the magistrate sees fit. Being unable to rely on its consistent application causes prejudice and uncertainty, especially when the opposing counsel is exploiting rules as a litigation strategy to overcome the lack of substance of the actual legal claims. In response to 112, a simple request for alternative service for a third-party witness who has evaded in-hand service. It's a town of 100 people. How are you not able to serve? Is he like Houdini? Oh. The magistrate ordered an expedited response. Plaintiff's counsel opposed the request, asserting the Local Rule 7.1c certification was improper because the undersigned did not wait 24 hours to file after emailing the plaintiff's counsel. You didn't. 6 p.m. to 9 a.m. is not 24 hours. It's 15. April 1st, magistrate denied the motion stating defendant's counsel did not at least 24 hours for plaintiff's counsel to respond as required by the local rules, Northern District of Florida 7.1b. Accordingly, defendant's motion 112 is denied without prejudice, which means file the 7.1b or certificate and refile it. Oh. The next time an attorney in this case files a motion without complying with the conferral requirements, local rules, the offending attorney will be sanctioned. But when the defendants filed a motion to strike, document 44, the plaintiff's motion to seek new part. And this is something I didn't catch yesterday when I was reading through it. He brings up document 112 or 120 on April 1st. 120 was denied because of the local rule requirements in 24 hours. But he's going all the way back to document 44, which is back in what, November? The plaintiff seeking to add new parties to the case for failing to have a meaningful conference before filing the 7.1c certification. The magistrate immediately issued a ruling saying no response from plaintiff is necessary. The motion to strike lacks merit and is denied. Like, I just can't with this dude. Like, I just can't. You're trying to bring up something from like November. I just, as explained in Order 102, the magistrate ignored the lack of certification in 96 altogether, as well as the citation. I don't think he ignored it. I think he said, okay, we need a show cause hearing because this is ridiculous. I don't think he ignored it. I think Randy is still going to get admonished for that. I just think the stuff in 96, because all Randy, if he said he denied it without prejudice, Randy would have just refiled it. But I think what was in 96 was too monumental for the judge to not bring everybody in front of him and be like, what the fuck? I think 96 was... as well as the citation to his own prior ruling, First Baptist, on the same issue, opening the floodgates. And then he brings up in a recently filed 10-defendant lawsuit by the plaintiffs that has been referred to the magistrate. Magistrate granted an uncertified motion to extension to file an answer, document 12, by one defendant, but denied the undersigned's request for an extension to answer that lawsuit in which he is a defendant because Matskin's motion fails to provide any indication that he conferred with plaintiff, and also fails to. This is not, Bruce, we went over this yesterday. If you're listening, because I know you stalk me. This is completely different. The Christopher Gage, the lawyer for MLS, he literally put in his motion multiple times that he had spoken to Randy. So yes, he didn't include the 7.1c, and the judge admonished him for that. The judge said, hey, next time, by the way, gave him a warning, but it was clear in his motion multiple times that he spoke with Randy and Randy agreed to a 7-day extension. Bubbles put nothing in there of the like that, and it gave any indication that he ever spoke with Randy or tried to speak with Randy. So he's putting two issues or conflating two issues that aren't, like, we put the motion side by side yesterday and you saw the difference in the two motions. They are completely different. Like, completely different. It's just, and that's good point. BM's expert won't be allowed in court. 96 was dispositive and default judgment, and by rule didn't require a conference. Good point. Very good point. Thanks for pointing that out, because I failed to. The motion is denied without prejudice. Stop bringing in other, that undersigned must confer with his opposing counsel in this case as a defendant in another case is extraordinary circumstances marking the present case. Those two things aren't related. Aren't related. Yeah, but it's a good point. Ruh-roh. This case is part of the plaintiff's Bad Neighbors YouTube storyline, using contrived claims in court litigation. This is where he starts to really not bring up anything with the judge. This is where he tries to litigate an emotion. Rather than this is where I have a problem with Bruce's stuff. This litigation is extraordinary, is made for YouTube. by a celebrity suing his private, poor, bad neighbors on a contrived basis to generate compelling content for his channel, What the Hales, rather than existing in obscurity on Pacer. Hello, I have a Pacer account. You know how many... You're fine. Sorry, my robot vacuum is in here and she's... Are you okay? Should we put it back? Should we put it back? Yeah. Okay, no. Do you want Mama to put it away? Yeah. Okay, I'm gonna send my There you go, baby. I sent it back. It's gonna go dock and we'll do it later, okay? Okay. Squidward Bubbles, get your ringside seat live at the Houston Astrodome. It's one of those like I just can't. Hey Redis, how are you? It's technically not stalking if I don't know about it, right? All of the parties' filings and the magistrate's orders in this case are instantly and sensationally amplified to hundreds of thousands of YouTube followers on the case. On YouTube. I wish I had hundreds of thousands of followers. That sounds like fun. But this is not my only Pacer case. I have 5 cases on Pacer right now. 5, 6. So like, dude, it's nothing lives in obscurity on Pacer. Trust me. Somebody is always following something, and just because you aren't following and you're not the center of attention in those cases doesn't mean they're not followed. Like, we still have to get through the rest of the Ruby Frankie and Jody Hildebrandt shit show. Channels profiting from the content. Channels profit from content because that's what YouTube is about. That's why people get monetized, so they can, make a profit on YouTube. It is fun, don't get me wrong. And a lot of people do it for fun. But some people, like Jeremy, do it for their living. That's how they make a living. So, of course, Anthony Shea's case is Orange County, Florida. Same. She knows how. She usually takes it off the charger. One day, Mr. Squid texts me. He's like, "Will you put the vacuum cleaner back on the charger so it'll charge?" I'm like, every time I do, she hits clean. We went back and forth for like 5 minutes of me hitting dock. Every time it went back to dock, a minute later, she would press clean and it would leave again and it couldn't charge. So, you're still following Laura Owens and her fake pregnancy. Yeah, that is. Yeah, I saw that. We're gonna get to that. I just have to get through this first because otherwise I confuse myself hopping back and forth, and it's just. Yeah. The magistrate has been oblivious, insensitive, or willfully blind to this dynamic of YouTube driving this litigation. You've put enough YouTube videos in, and Randy has put enough of the Fleas YouTube videos in. The judge is not oblivious or willfully blind to this dynamic. It doesn't impact his decisions right now because discovery is not done. After discovery is completed, it might matter more. But right now, it does not matter. Provoking the magistrate with a strategic inflammatory motion, such as 96. Oh, he's really pissed about that. Has resulted in YouTube content beyond what the plaintiff could have reasonably hoped for. I really hope so too. It's not even the way Jeremy makes a living so much that he shares his life as unemployed, showing how Grace's life has been. They entered his life, it was their fault. Yeah. Oh my goodness. This is what I was hoping for. And sorry, chat is moving fast. Confused Gingras with Matskin is easy with the motions. Yeah, and he gets pissed when you compare him to Gingras too. But remember, he reached out to Gingras. So, like, yeah, in 2023, yeah, we've got that. There's been dozens of federal court updates videos with content purely from this litigation. Each generates significant income for the plaintiff. This is one of a number of court actions by the plaintiff against the present defendants to vex. He brings up all the other cases. An acronym of polyflop has grown out of the plaintiffs and his counsels. It hasn't grown. You tried it. I'm just going to say this. I don't know how to believe. The only one I'll believe is the judge only. Yeah, and it's then Bruce, stop giving that. That's the thing. Since I only read documents and I don't investigate people's pasts and talk about people's pasts or other journalists, Josh J. Hip is doing a really good job with the Michael Volpe situation. I don't cover that. Yep, Sandra, I appreciate that. I am aware of it, but we're going to get through this one first. We're trying to skip through some of it. The district judge can vacate consent to a magistrate under federal or civil procedure, blah, blah, blah. Yep, and he basically just cites different cases. Or when a party shows extraordinary circumstances, the district judge may vacate a referral to a magistrate judge under this rule. I don't think he's going to. I believe the district judge will be less lenient with these people than Bolitho is. While the standard of extraordinary circumstances has not been precisely defined, and you sure as shit did not define it in this motion, what this court agrees with the district court's findings in Rivera that it's sensible to construe this standard consistent with the notion that a party's waiver of the right to proceed before an Article III tribunal must be knowingly involuntary. A party should be allowed to withdraw consent if proceedings or circumstances arise from the party neither could nor should have conceivably foreseen at the time the party excluded the waiver. Jesus, Pete, man. I just can't. Just can't. Oh, yes. Flash Fan has a Discord where he screams classic trials. Like old school trials. Ones where you look at the fashion and you're like, did I really wear that? Extraordinary circumstances have been shown warranting vacating consent to a magistrate. No, they haven't. The undersigned's zealous advocacy has been chilled by the magistrate's threats. That's not zealous advocacy. That's harassment and annoyance. And in response to contrived inflammatory filings by the plaintiff's counsel, thanks, Mike. I'm not going to lie, there are some people who are regulars in this chat now that when they first got here, I was like, I need to keep an eye on you because, you know, I need to keep an eye on you. If you know, you know. But now they're regulars here and they're pretty respectful to me. And what y'all do in the other 22 hours a day I'm not streaming, it's not my business. Hi, baby. Okay. Here you go. There you go, boo. Yeah. The magistrate appears to have a grievance against the undersigned for crossing some line, although it's not clear. No, I'm pretty sure the judge made it clear, and it's not just you. Okay, here is my thing, and y'all can feel free to give me your opinions on this. If the judge, or if the bubble side of things thinks that the judge hates him, and what the Hales side thinks that the judge is mean to Randy, doesn't that mean that the judge is doing his job? Because then he's mean to everybody, and there's no like, you don't discriminate, you're mean to everybody. Yeah. Hey, poor Marine. It's just something special. Honestly thinking that BB is trying to lay a basis to have the potted plant uprooted. I don't think the potted plant a potted plant anymore. But the magistrate has already basically threatened to have the undersigned arrested, and his anger and vitriol towards the undersigned in writing and celebrated around the world by the plaintiff's followers. So the plaintiff's followers actually have been really, really pissed off at the judge for being mean to Randy too, and saying that it's not warranted to be mean to Randy. So the fact that Bubbles is internalizing this, that it's all him, is not accurate. Moreover, some of the plaintiff's ardent followers publicly announcing plans to make pilgrimages like it's a religious affair to Pensacola for the April 3rd event is frightening prospect. You know, people went to Arizona for the June hearing for Laura Owens, right? Like Dave Neal, Megan, Roslyn was out there. There was quite a few people out there who went for the so-called spectacle. So it's not unheard of and it's not new. Like, get over it. Who's seen by the plaintiff's followers as a hated villain, being jailed as disbarred. No, you deserve to be disbarred because I've proven on my streams comparing your actions to the Florida rules of professional conduct that you are, in fact, unethical. At a minimum, the undersigned's appearance would result in being involuntary videoed for YouTube content. You go on a YouTube podcast multiple times from what I hear per week. Like, what's the difference between taking audio from that and videoing it for themselves, other than you can't remotely begin to try to copyright strike people. There's the problem. He can't copyright strike anyone. Depending on the outcomes of the proceedings, mocked for his misfortune, you're going to be mocked for anything you do because you're a ridiculous piece of crap. Like, yeah, people went to Korea for a YouTube case. Yeah. If you hate, well, stats, something like this. If you hate me, but you watch everything I do, you're a fan. Just be honest with yourself. And the thing is I just laugh because it's like, whatever. Like, I'm not letting somebody that I don't know on the internet try to like make me feel bad about myself. It's just not working. No. This motion will be the subject of hours-long YouTube live streams, beginning with a few hours of its filing. Ain't that the truth? And undersigned's arguments and motive will be attacked and maligned by the plaintiff and his followers, who will spin fantasies about the undersigned going before the magistrate if this motion is denied. This is not the practice of law. It's turning federal court into a circus. No, it's called transparency in our court system and public interest. All right. Trying to make it the greatest show on earth. You are the circus in yourself. You are the circus. It's extraordinary that counsel in a simple one plaintiff, two defendant defamation case fears being arrested by the magistrate. He gave that warning to everybody, not just you. Stop thinking you're the center of attention. No lawyer should be casually threatened with arrest, let alone for petty nonsense, such as what frivolous, contrived civil lawsuit consists entirely of. Oh my God. Oh my God. Oh. I just can't. So he basically says 2 clients' unemployment hearings where they will be left unrepresented, his wife's medical appointment to take her to, why can't she go by herself, and his own long-awaited dental appointment that would be postponed for months. Oh my God. Oh my God. This poor dentist. He can't go to the dentist. Oh my God, he can't get his teeth cleaned. This motion is filed regrettably and with trepidation. Yeah, but with firm moral conviction. You do have proven that you have no morals. Like, yeah. All right. Hey, and then exhibit, he brings up the other lawsuit. He brings up the Ohio protective order. He's bringing up things that aren't related to this case. And like I said, my history of writing is business and medical, not legal. But in medical writing, I would never bring up something that is not involved in my actual case that I'm working on. Don't bring up like something that happened to your patient 20 years ago or something that happened in state. It does not affect the current situation at all. That's why that one person who wanted to hate on me, Lori Gray, whatever her name was, she was like, "You're not going to read the past stuff?" No, because that has no bearing on this. The judge doesn't give a shit. Like, the emergency custody proceeding to save Preston's child. He brings up her custody proceedings and the whole like Miami law group and all that, and that is not appropriate to bring up in this lawsuit. Sounds like an emergency. It sounds like it's not an emergency. All right. So that's the end of that. We are going to go on to Pacer, and we are going to look up. Jeremy B. Docket report. This is how you save money on Pacer. You only go by what is filed the latest, and you won't get charged like $2 to look at the you won't get charged $2. You unclick the parties, and then this is what you get. And you only get charged 10 cents to look at it instead of the dollar. I think it's like $2.20 now if you look up the whole thing. 50 cents. 5 pages. Oh, great. This is the new ones. Yeah. Sean, earmuffs, baby's good. Bubbles just filed this 27 pages word vomit. Here's his latest issue. Yeah, the patient in the room next to mine needs physical therapy, so I want it for my patient. Yeah. Yeah, that's pretty much the where we're at. All right. Notice of defendant's counsel's inability to appear April and request to decide motion 96 and show cause based on 115. Footnote 1. I like putting footnotes in the titles. What? Yeah. Yeah. Y'all caught that? Based on his history, BBB has no respect for judges or other attorneys. He seems to have made a habit of attacking his own. He seems to feel he is smarter. Yeah, he's the Sarah Boone of lawyers. He thinks he's the smartest person in the room and thinks it's his job to correct them. Yeah. It's good so your brain is protected. I don't think anything could save me from this headache. Daniel. But Lynette takes her to the flea market in Walmart. Yeah, Walmart is the last place that I would want to take somebody with health issues, especially the Walmart here. The defendants give notice that their undersigned counsel is unable to appear on April 3rd pursuant to Order 98 because it was impossible to make the trip. No, it's called a credit card and an Expedia. I looked it up for you, BBB. And also because he fears for his safety and freedom if he attended. Oh, you're going to fear for your freedom now because the judge is not going to take this very well. If the proceedings are not stayed sua sponte in response to this notice and or the pending district judge ruling on the defendant's motion 123, the defendants respectfully ask their responses in 115 be taken under advisement in ruling on the plaintiff's motion number 96 and on the court to show cause. Hold on, baby. There you go. I know mommy's water always tastes better, even though it's the same thing. Hey, you act like you've never taken a drink before. And on the court show cause Order 98. Oh. That's true. I'm going to have to use my tens unit to my neck. Yep. He rivals my mother-in-law. Yeah. He knew about this date, and all of a sudden he has a case. Yep. Yep, 800 milligram ibuprofen. That's how they fix every situation. You need surgery? 800 milligram ibuprofen. It was impossible for the undersigned to resolve calendar conflicts, including client hearings for which they'd be left unrepresented, which could lead to disproportionately negative consequences for both the abandoned client and the undersigned. This notice is filed at the risk of sanctions for not being deemed an emergency, but the undersigned felt this was the proper course, even though implicit in 123 that the undersigned would not be intending. The undersigned also has family obligations he cannot possibly leave behind for up to 3 days. And there was no possible way to make all necessary arrangements for his family members' needs to be covered in his extended absence. 3 days is not an extended absence. The undersigned wife had a rope care cuff tear, which would require the undersigned's assistance with many daily activities. Hire a home health aide. Or your children can do it. The undersigned's daughter would miss an important band rehearsal. Oh my God. She can't. Okay, this right here. This is not an excuse. Band rehearsal. She doesn't have anybody else in that band that could pick her ass up. And also be significantly affected by her father's unavailability to bring her to school and pick her up. It's called a bus. For reasons that the undersigned is not going to discuss here, other than to say that it prevents him from traveling to Pensacola. Footnote 2, the cost is also extremely burdensome and disproportionate for the defendant's pro bono counsel. They don't have to be there. You are, especially when combined with the financial impact of his law practice being away for several days. You took a case in Florida. What did you expect? Never have to go to Florida? The marshal has a travel plan. Yeah. Yes, I believe, Marcia, I believe you are correct. This was the plan all along. I was hoping for the best, but you know. Adding to the already huge financial impact on his practice of litigating on behalf of the defendants who are indigent against an aggressive plaintiff and a well-financed counsel. The undersigned apologizes for any filings or contents, whatever, that have offended the magistrate or incited his annoyance. Yeah. Oh, just wait. Oh, just wait. The undersigned has sought only to zealously advocate on behalf of his clients and does not believe he has transgressed any professional rules of conduct warranting sanctions or revocation of his mission pro hac vice. Oh, you're done. Or that justifies and necessitates the expense of hardship of a multi-day travel, or has justified the turmoil of his personal life and practice since the filing of 96 and the court's orders that incited it. The undersigned, footnote 2, here's my sob story. The undersigned's children's late biological father passed away while on a work trip in 2015 when they were 5 and 11. The undersigned adopted them after marrying their mother. Any extended work trip, taking their father away from home, creates anxiety for them. Well, you shouldn't have taken a case in Florida. Yeah. That many of you guys have said it. Oh, yeah. Anxiety for them as a result of that experience and its lasting impact that occurred when the undersigned was ordered to travel for the December 19th deposition of the plaintiff that ended up not returning as planned due to flight cancellations. Well, the defendants believe it's obvious that Motion 96 was intentionally contrived and filed by surprise for the very effect it had, and that as 115 demonstrates, the subject emails do not remotely justify sanctions. He explains them again, as if the judge doesn't know. The plaintiff's surprise on certain uncertified motions for sanctions is the epitome of the acronym polyflop, having incited immediate multiple court orders, responses, additional filings, more orders. No, it was, never mind. Yep. A couple, I want to say at least 2? Liberation Day. Oh my God. I will be back this afternoon because I know that the judge is going to file some shit today. He puts another YouTube issue. None of this multitude of proceedings might have occurred without the calculated non-certified 96 being filed, or for surprise effect, or to lack of certification ignored in denying the defendant's motion to strike it. For that reason, the court, magistrate, and district judge alike can take judicial notice of the use of these events to generate YouTube content for financial profit on the plaintiff's channel, What the Hales, and other channels profiting off the content generated by this litigation. This is another question I have. Well, Lynette and John aren't paying, and they're getting what they paid for. Squid, if you're Randy, do you just keep quiet but go through all of this and lay out step by step the responses to have for the hearing? I would lay out all my stuff. I would keep it to myself. I would show up to that hearing tomorrow as if Bubbles was going to be there, and I would just lay it all out for the judge. I would not file anything. I would let the judge handle this because there is no response that's needed from this. This has nothing to do with Randy. This is everything to do with Bubbles and the judge. Randy just needs to sit back and chew some bubble gum and twiddle his thumbs, get everything ready for tomorrow, and just show up and go about his business. Yeah. Just as long as they propagate the plaintiff's claims and attack the defendants and the undersigned. I have never once attacked the defendants. I've attacked Bruce because I just give Bruce my opinion. It's not truly an attack, but it is what it is. But my issues with all of this has been strictly against Bruce, not the defendants. And I don't propagate anything that Jeremy doesn't tell me what to say, and that's fine. And he knows that. And he knows that. And Jeremy doesn't hate me for it, I don't think. If he does, he's never said it. There was only one person or one group of people who's attacked me in this, and that's been Bubbles and his loyal band of merry men or women or whatever. I don't know. This is not an attack on their First Amendment rights. Bullshit it ain't. But to show the true motive and purpose for this simple one plaintiff, two defendant deposition case. It's not a deposition case. Having been initiated and turned into the spectacle it is by the plaintiff, you never should have tried to threaten someone who has 700,000 followers as if they're not going to tell everybody on their YouTube channel what's going on in their life. Ay, 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 yay, yay. Oh, just what the royal, oh my God. This should be relevant consideration for the court to carefully examine the issues of the plaintiff mislabeling non-actionable statements as extortion. And what happened about that $65,000? What is that? That's not extortion? I'm confused. I'm confused. This is not like me being snarky. This is me being like, well, what do you consider asking for $65,000 to make John go away and leave Lynette alone? Like, what do you consider that? Like, I'm confused. Because that strikes me as extortion. Jeremy's YouTube is about his life. What did he expect? Yeah, very, very good point. Very, very good point. like, And that's not like, and that right there is not defending Jeremy. That is stating that YouTubers tend to mention what is going on in their life on their YouTube channels. And when Jeremy's channel is all about his life, did they not like, I am in this motion? Oh, great. Interpose, or the plaintiff's non-actionable statements is extortion, and interposing a possibly perjured affidavit is about non-existent online statements calling me a child rapist that are consistent and ongoing to this day. To invoke federal jurisdiction in denying a 12B1 motion, the court did not meaningfully examine whether federal jurisdiction was fraudulent, invoked as a part of litigation for content enterprise for entertainment and profit at the expense of indigent defendants and the court's time. And oh, shit. Oh, I did make it in. Damn, I gotta screenshot that. That's me. That's me. What can I do for you, beautiful? Yeah, cupcakes. We're almost done, and then we're gonna go get lunch. Okay. Okay. Yay. The undersigned is unable to attend April 3rd, also for the reasons detailed in motion 123. From the court's orders, it appears the court acted precipitously in response to the filing of 96 and was unwilling to consider altering those orders, regardless of lack of certification. The response to it filed by the defendant 115 or the glaring issues detailed in 68, going directly to the improper invocation of federal jurisdiction by the plaintiff. All right, some directly associated with the plaintiff, him periodically appearing on their live streams to discuss the case, which boosts their view counts. Please take judicial note of YouTube channels Tug, Megan Fox, Shizzy, Veteran Nation, and Squid Pro Quo. Jeremy has been on my channel once for approximately 5 minutes. I asked him 3 questions after the December 19th deposition, and at least 2 out of the 3 were about the judge. So, he's drinking the Delulu lemonade. And somebody spiked it with something. Our one channel, DUI guy, is a Kentucky lawyer, Lori Foreman, who profited from coverage of the plaintiff's legal cases and involved in a fundraiser held live by the plaintiff on YouTube to raise money for the biological aunt of defendant Preston's adopted at birth daughter, who'd never met the child, to hire a law firm to file a fraudulent emergency custody petition, a months-long content-generating storyline on the plaintiff's and the others' channels that to serve as to terrorize defendant Preston, with the plaintiff promising his YouTube followers that she would have her child taken from her. Mr. Foreman also frequently attacks the integrity and qualifications of judges. Yes, but no, including the gratuitous claims of being biased or corrupt to feed narratives he is pushing for entertainment process. He literally shows court feeds and court video from his own trials, like in his own hearings. Like, that's not, no, that's, and I'm sorry, but a lot of thumbnails are clickbait, which is the point, because you need people to click. Yeah, LawTube was big on what the Hales without what the Hales. Like, I'm sorry, like 99.9% of LawTube and people who watch LawTube had no idea who Jeremy Hales was before all this. They watched, Larry had, I think after the Johnny Depp case, he had what, I think he had over 100,000 followers just from Johnny Depp. Like, it's not, no. Oh my goodness. As explained in 123, the undersigned. Did you run over your toes with the chair? And then wonder why your toes hurt? Come here, baby. Come on up. As explained. Oh my goodness, it's lunch and nap time. I got you, baby. Oh my goodness. Yeah, baby. Take a drink. Calm down. Oh, it's okay. I know. Hold on. Okay. All right. Legitimately fears for his freedoms and safety, and so cannot attend and place himself at those risks in good conscience with his family and clients depending on him. If he'd done anything remotely justifying draconian consequences just to be able to defend himself, he wouldn't be risking whatever consequences there may be for filing this notice and not traveling from Boston to attend on April 3rd. Oh, and you notice there's no 7-1. Just a FYI. Okay, we are going to download this 2025-4-2. And no, this is not an April Fool's joke. Yeah. Okay. That's just I just can't, like, that was 124. That was 124. Yeah. That was 124 that we just read. We're just gonna see if there's anything else. Yep. So he's not going, and we shall see. No, there's not a judge's order. Right now, there's nothing. This is the latest and greatest right here. So we are going to check the docket in the other case, though. To see if anybody's got their. Nope. So nothing has been filed in the other case either. So, on that note, we are going to get going. I am going to go give the little one lunch and try to get her down for a nap. If I will keep tabs on the docket, and if anything comes up from the judge, I don't think. Part of me thinks the judge will file this afternoon, and part of me thinks the judge will file tomorrow after Bruce doesn't show up. Because right now, reading that, I think the judge will be a little bit too angry. I don't think that the judge will. I don't think that the judge will take that very well. If I was Randy, I would not say a word. I would just show up like I don't know anything. I would just get all my stuff together for tomorrow, like tomorrow was going on as normal, and I would just act like you're, yeah. I think it'll be late tomorrow, because Randy should just show up at 1:00 because it is scheduled. He should just be there like nothing's wrong, nothing's happening, and let the judge do what the judge does. On that happy note, I think we are going to go over to, I think AJ is live. I think AJ is doing Eileen Warnos, which is like, there's 382 of you guys still here and only 247 likes. So can some of y'all, before I mom shame you, I learned to mom shame from Megan. Are your thumbs broken? Are your thumbs broken? Wouldn't your thumbs broken? Like, do we need to figure out how to do this now? All right, customization. Bye, Kathy. We are going to redirect. We are going to go to Eileen Warnos penalty phase, day 1. So if y'all don't remember Eileen Warnos, it's time to get a do. I believe he could. I don't know if he will, but I believe he could. But I definitely think Bruce is going to get some severe consequences for this. So y'all tell AJ that I said hi. It's going to be a great day. Like, thanks, guys. Yes, please hit that like button. And if you haven't subscribed, please do. I would greatly appreciate it. I just can't imagine that this situation is going to go well. But thanks for joining me. I hope we didn't give you too big of a migraine. But y'all have a great day. I love you guys.
Bye.
Can you say bye?
Bye.
Oh, now you're all happy?